Okay, Pradeep ji.
Sure, sir. No problem. I can wait. Am I audible though?
Yes, you are.
Yes, sir.
Thank you. Can everyone see the screen that I'm
Yes,
sharing?
screen is visible.
Okay, all right. Just let me know when to start and then I will commence.
Sure.
I guess we can start, Prashant.
Yes, we can start now, I believe.
Yeah. Good afternoon, Pradeep. Thank you for hosting this session. Good afternoon, everyone. I think Pradeep needs no introduction. He's been a legal consultant to ISODA for a long time. So let's go ahead with this session. And apart from that, I would also request members who are attending and even not attending, to whom we will send this uh, recording of the video. Please feel free to reach out to Pradeep. He's very supportive and knowledgeable in addressing any legal queries you may have. Over to you, Pradeep.
Pradeep ji, I believe you will also have some sort of a Q&A after the session.
Sure. We can have some question and answers after I'm done with this. Adding to what sir had just informed the meeting, this is a PDF file which I have prepared for the purposes of this webinar. I can share this also, which is actually a much easy access to information. Once the entire meeting is over, it can be
Yes.
shared with the entire
So
group.
you can share it across to members at isoda.in and everybody would get it.
Yes, exactly.
For your benefit and everyone else's, I will just put the email ID on chat.
Sure. No, once the entire thing is over, I will mail it on the website, on the email, so that everybody can get access to it.
Okay, thank you. Over to you, Pradeep ji.
Thank you, sir. Thank you so much. So today I have been asked to speak to you with regard to a particular topic, and I would like to thank the members of the ISODA board for giving me this opportunity to address you all on this one particular topic. The topic that I have chosen today to address to you is risk proofing your tech venture. It's a legal survival guide. Now, why are tech ventures, especially startups, susceptible to legal issues? It is so because startups aim to innovate rapidly, often challenging or bypassing established norms that may contradict with existing laws or might create gray area. Now, being an expensive industry, tech ventures prioritize marketing and product development over legal requirements because the urgency is always in trying to push the product into the market to monetize it as quickly as possible. So sometimes what happens is some legal requirements which needs to be done is often overlooked, is what I have come to found out over the course of my experience. Now, this might lead to problems in intellectual property protection, contract laws, company laws, and also in compliances with various industry regulations. The tech startup as such tends to disrupt established industries such as transportation, finance, healthcare, and media. And this disruption is usually caused by providing services or products in new ways that bypass or reimagine traditional business models and practices. Now, keeping that in mind, what are the types of risks that are potentially faced by tech ventures? Now, you can see in this page, there are so many different kinds of risk. We will go through each and every one of them in this webinar. One, intellectual property risk, data, privacy and security risk, contractual risk, regulatory and compliance risk, employment and workforce risk, product liability risk, technology licensing risk, investor funding risk, litigation and dispute risks, cybersecurity and fraud risk, and reputational risk with legal consequences. Now, with regard to all of this, we are going to go in detail with regard to the first five: intellectual property, data privacy, contractual, regulatory, and employment workforce risk. Now, intellectual property risk. What exactly is an intellectual property risk? Intellectual property is a term defining the creations of the mind, such as inventions, designs, literary, and artistic works. Intellectual property includes trademark, copyrights, patents, designs, and trade secrets. Intellectual property rights also protects the intangible creations of the human intellect from being wrongfully profited by others. To give a simple example of an intellectual property, I'm sure everybody has heard of the term hook and loop fastener mean. Now, hook and loop fastener is a method that is typically used to stick together and remove easily two pieces of clothing. It is used in our everyday lives. This is nothing but Velcro that we all are aware of. Now, Velcro actually is a company founded in Switzerland who initially patented the hook and loop fastener method. In or about 1978, the patent of hook and loop fastener belonging to Velcro expired. However, the word Velcro now remains to be a word trademarked by the company. The word Velcro is nothing but it's derived from two words, velour, that is loop, and crochet, that is hook. So, Velcro. Now, each time the word Velcro is used, it is not the product, but it is the company's name that is being used. This is a classic example of patent and trademark. Now, a life of a trademark in India is 10 years. Generally, it can be repeatedly renewed for a further period of 10 years. However, a life of a patent in India is for 20 years and it cannot be renewed after 20 years. The life of a copyright in India is for a lifetime of the author and for 60 years following his death. Any entity carrying on business without registering for trademark shall not be entitled to claim for damages in the event of any other entity with a trademark registered, even if commenced later. So basically, this means that if basically X starts a business and he trademarks and he forgets to trademark something, and Y starts a business much later than X, and he trademarks his brand, which is quite similar to X, Y will get the preference because he has registered the trademark. For example, and with regard to patents, examples of patents can be any algorithm for any function, aesthetic features of a product that can always be patented. And patents generally is used in inventions and, when there is some sort of a scientific basis to it. And there is always some sort of technical know-how is needed for patents to be registered. Now, trademark, we all know what trademark is. It could be the name of the company, it could be the name of the brand. That could be a trademark. Like, for example, iPhone is a trademark concept that nobody else can use. Copyright, we all know it can be literary work, but in our source, it can also be a software source code and or a multimedia content, etc. Now, the risk of infringement, wherein startups inadvertently use patented technology, copyrighted codes, or trademarks registered by others. Now, in order to avoid this, adequate due diligence is required. For example, when you start a business and if we are going to use any software source code, there are two things we need to do. One, we need to do our own due diligence to see that our software source code has already not been copyrighted. And if it is not been copyrighted, then we should take the step of copyrighting it in the first place. Regular audits are recommended in order to make sure that there is no infringement of the trademark by anyone else, or to check if we are not infringing anyone else's trademarks, thereby protecting ourselves from unnecessary lawsuits. Now, the various risks that is involved in a intellectual property field is usage or distribution of content with or technology without proper permission of or licensing, and it can lead to infringement claims. Now, what is the solution for that? The solution for that is to use clear contracts to define the scope of the use and the licensing terms, especially with open source components with clear licensing agreements, which establishes what we need to do, what we need not do, what we can do, what we cannot do, who we can share with, who we cannot share with. That sort of a clear cut contract will always, help us with regard to infringement claims. Second failure risk that we can possibly be faced with is failure to secure a patent, a trademark, or copyright exposes tech ventures to potential IP theft. So the proper solution for that is, obviously, if you create something, any software source code or any so trademark or brand name or whatever it is, the first step that we need to do is register with the proper appropriate authorities to secure exclusive rights over these inventions, patent, branding, trademark, and software copyright. So what happens is that if you register yourself, if you register your patent or your trademark or your copyright, and if somebody else is using this, then you can sue them from stopping them, and you can also possibly claim for compensation. Vis-a-vis, if we are using somebody else's trademark or patent or copyright, we are subject to such lawsuits, and we will be exposed to various risks. So therefore, it is very essential that whenever we start a venture, one of the first things we have to do is to exercise proper due diligence to see whether such a trademark or such a soft patent or something is already in existence. If it is not, the first thing we have to do is to register our patent or trademark. Now, another possible risk is integrating open source software improperly may violate licensing terms. Now, the only solution to that is to regularly review the technology assets to identify proprietary elements and to ensure appropriate licensing through IP audits. IP audits is what I mean by saying, every once in a while we need to properly do a due diligence with regard to, is there anything already there? Is there anything that's already been patented or copyrighted or trademarked? Next risk is suppliers or competitors might claim ownership or technology or processes. Therefore, the solution for that is to protect sensitive information shared with partners or contractors by way of an NDA. That is a non-disclosure agreement. Everyone in ISODA, I think, is very much aware. One of the most important maximum number of documents that I get for vetting is a NDA. That's a non-disclosure agreement. Because a non-disclosure agreement is a way by which you protect your own knowledge, your own information from being accessed by someone else and unscrupulously. The various laws governing IP is Copyright Act of 1957, Patents Act of 1970, Trademarks Act of 1999, and Design Act of 2000. Every city has a trademark registry, and we all have the option of applying for it in that particular city. We also have an option of applying for an international trademark. Obviously, for that the expenses will be much higher, but then it depends on your usage also. So that concludes intellectual property risks. Now, next we are moving on to data privacy and security risk. Now, as tech ventures thrive on data-driven innovation, understanding the legal landscape around data risk is crucial. India, like never before, has for the first time introduced a new act, which is now called the Digital Personal Data Protection Act, which has been enacted in 2023 to provide a very robust framework with regard to protection of our personal data. Usually, the mistakes that occur in data protection are those wherein the entity fails to obtain the consent for storage of the user data which is collected, or fails to safeguard the sensitive personal data like information, financial information, or health information, or fails to comply with localization rules. Recently, I think you must have heard there was a massive breach of data from Star Health Insurance, where one of the senior members of the Star Health Insurance company had sold a lot of health information to one hacker. Now that falls under the violations in the new act, that is the Digital Personal Data Protection Act. Now that case is still pending, it has not reached its finality, but these kind of mistakes may result in fines of almost up to 250 crores as per the new act, depending on the facts and circumstances of each case. Now, we need to make sure that we need to report any breach, leak, hack, or any other cybersecurity issue promptly to a particular organization that has now come into existence called CERT-IN, that is Indian Computer Emergency Response Team. Any delay in reporting can cause data loss, creating a liability for damages to affected users, which will also lead to consumer cases, creating huge liabilities. For example, in the Star Health insurance case, I am sure that any person whose information has been leaked, they very much have a right to file a consumer case against Star Health for misuse of their personal information, especially their health information. Now, in the inadvertent use of data for more purposes than what it was disclosed for can also lead to a fine and even imprisonment as per the new IT Act of 2000. Now, therefore, in order to, you know, be on the right side of the law, we must conduct regular audits to review with data loss and to also make sure that our firewalls are strong enough to prevent them from being hacked. And, so these data is not leaked by any way. Explicit express consent also has to be obtained as a matter of abundant caution for extraordinary circumstances that might arise. So that means that we also need to have some sort of a limited liability clause in our agreements with, when we receive data, that there could be a possible leak, that we cannot be, responsible for that if it is not within our control. Then for that purposes, we also need to adapt to standardized clauses in contracts to be entered for cross-border transfers. Now, what are the various risks with regard to data privacy and security risk? One, violation of laws like Digital Personal Data Protection Act of 2023, which is very much similar to the General Data Protection Regulation of the EU and can result in heavy fines, as you have already seen, up to 250 crores. Now, the solution for that is we need to adopt the data protection policy aligned with the global GDPR and also local privacy laws, which is the new Data Protection Act. The second risk is mishandling personal or financial data can also lead to legal liabilities and loss of trust. How we can safeguard from that risk is to use encryption and adopting security protocols such as access controls and multi-factor authentication to protect our data. The third risk is usage of unauthorized data without proper consent can lead to consumer cases. How we can stop that is by obtaining explicit consent for data collection and usage with clear disclosures to users. Even there, we need to clearly lay out the area as to how our data is being used, how it is going to be collected, and if we deviate from that, we are liable, to be sued by them. The last risk is non-compliance with data transfer laws in cross-border data transfers, which can lead to various restrictions and injunctions. The only way to get over that is to have a proper standardized contractual clauses for cross-border transfers, which we can find in standard contractual clauses of the EU that can always be some sort of a Bible for us, from which we can, derive clauses and put them in our contracts. Now, the various laws governing data protection in India is Information Technology Act of the year 2000 and Digital Personal Data Protection Act of the year 2023. Now, we are moving on to the next risk, that is a contractual risk. A contract is an agreement, either written or spoken, between two or more parties that creates a legal obligation.
उसमें से एक डॉक्यूमेंट जो मैंने फाइनल किया है
I think somebody else is.
वो जो 2 पेज का था ना, जो ओरिजिनली हमने बात की थी, तो वो क्यों नहीं भेज दे, भले लिंक नहीं हो क्या?
Let me start again. A contract is an agreement, either written or spoken, between two or more parties that creates a legal obligation. Now, the terms of this contract are enforceable by law. A contract is created where there is an offer, consideration, acceptance between two or more parties. Any contract needs to have an offer, acceptance, awareness, consideration, capacity, and legality to be enforceable by law. Offer is a conditional proposal made by a buyer to a seller. And if this proposal is accepted by the other party, it becomes acceptance. As to awareness, both parties to the contract must clearly understand and agree to the basic substance of the contract. The problem here is when there is any ambiguity in the contract, the person who drafts the contract will suffer the ambiguity. Like if X is drafting the contract and entering into a contract with Y, and X is drafting the contract, and if there is some ambiguity in the contract, that ambiguity will work against X. Therefore, contracts always have to be very clear, simple, and concise. Consideration. Consideration entails something of value proposed in exchange for actions or non-actions defined in the offer. The most common method of consideration is payment for goods delivered. Consideration in a contract distinguishes a contract from a gift as it requires the voluntary nature of requiring something of value in exchange for the promise. The next is capacity. The parties to the contracts must have to demonstrate their legal capacities to understand what they are signing. The parties signing the contract must be of sound mind and must be over the age of 18 as per the Indian Contract Act. In the event of a party being a minor, he or she must be represented by a representative. Now, the legality. Contracts are subject to laws of jurisdiction under which they operate. In our case, contracts are subjected by the Indian Contract Act of 1872, especially Section 24 to 30 defines void contracts. Various scenarios are elucidated in Sections 24 to 30 of the Indian Contract Act, which says that what contracts can become void, what contracts are void ab initio. Ab initio means they're void from the very beginning itself, or there are some contracts which becomes void by way of a certain act being done by one of the parties. Sections 24 to 30 clearly define each and every scenario. Now, for every key business arrangement, contract agreed must be put in writing. None would normally rely on any oral statement, email or text, etc. because to determine the terms of the business arrangement, a written contract is very much essential. It also must have to be binding on all the parties involved, reduce all important arrangement into a written contract. It should also pinpoint every arrangement and must not leave any room for ambiguity. Like I've already told you why there should not be no ambiguity in the contract. Now, a party must ensure the practicality at the time of entering into a contract also. Failure to enforce terms as agreed upon in the contract would lead to huge penalties and loss of business. A breach of contract often leads to civil and criminal proceedings against a party. Now, I always say this, and most members are aware of this. I always strongly recommend that any contract that you enter into should contain and clearly determine the dispute resolution clause, because any dispute, if it can be reduced amicably by mediation, by appointing a mediator, or in the event of a failure to resolve by mediation, an arbitration must be the next choice of dispute resolution, since it is fast and not as complicated as compared to proceedings at court. Now, I've always told this very, to almost all the contracts that I keep getting for vetting from the association. This is one thing that I strenuously, say that you please have a dispute resolution process, because going to courts is a highly taxing and vexatious process. You will be stuck in the line and you never know when it can be over. But if you choose mediation or if you choose arbitration, the arbitrator is appointed solely to, solve your problem. He's got no other business, he's got no other work. You pay one fee, the opposing party pays the fee, the arbitrator decides solely your case, so your dispute will be resolved quickly. And in a commercial world, any dispute that resolved quickly is actually highly beneficial. Only disputes that I have come across that's beneficial for long-standing exposure in litigation is personal issues, personal partition between family members. They are the only ones who benefit from long-drawn litigations. Now, as far as businesses are concerned, tech ventures are concerned, it is necessary that regular audits are also conducted to ensure that the parties are at capacity to make good the terms of the contract, making the contract relevant and beneficial to the venture. It is also suggested that the contracts to be entered into are vetted by a legal professional to ensure enforceability and to avoid disputes. Vetting of contracts might curb the gray area in the contract and give a clear-cut and concise picture as to what needs to be done, what needs to be given, and what is the consideration, when is the consideration to be paid, what is the term of the contract, what are the things that we can do, what we cannot do, who we can disclose, what we can disclose, all these terms can be interested in the contract. Now, what are the risks with regard to contracts? Now, vague terms in ambiguous contracts can lead to disputes and enforceability issues. Now, to get over that, we always have to ensure that all terms and responsibilities, deliverables are precisely stated, making a clear and detailed contract. The second risk is contracts without clear terms or legally binding elements may be void, making the contracts non-enforceable. So when a contract may become void, it's always better to have a provision for arbitration or mediation to resolve that dispute without litigation, without going to the court and wasting your time in the court. The third risk is failing to meet obligations, causing a breach of contract, which can result in penalties and business loss. The possible solution to that is to conduct regular audits of the vendor and partner contracts to ensure they remain relevant and beneficial to the venture. The last possible risk is misunderstandings over ownership or revenue sharing might lead to litigation. That, you need to always have your contracts ensured by a legal professional to avoid enforceability issues, to make sure that there is no misunderstandings and that proper revenue sharing is always precisely written in the contract by way of taking the help of a legal professionals. Now, the laws which govern contracts are the Indian Arbitration or Indian Contract Act of 1872. That sections 24 to 30 clearly lay down what are the contracts that is void, what are the contracts that can become void, and what are the contracts that is void ab initio. Now, coming to the next risk, that is regulatory and compliance risk. Regulatory risks those that occur when there is a change in the laws and regulations which will lead to impact a security or a business or a sector or even a market in itself. These changes are made by the government in the regulatory laws, may lead to increase in the cost of operating a business, reduce the attractiveness of an investment, or change the competitive landscape in any business sector. In extreme cases, such changes can also destroy the very business venture model. Now, the examples of a regulatory risk in the automobile industry might suffer increased cost as new emission standards are introduced, which impact their production processes and their bottom line. Given this situation, the automobile industry is left with no option but to comply with it, since non-compliance would lead to huge fines, which will lead to reputational harm to the brand as well. For example, I think you might remember when Volkswagen recalled a lot of cars because they failed to comply with the emission norms, and that had a lot of financial impact on them. Now, with regard to technology industry, misclassifying any software can lead to tax or licensing penalties. Certain cybersecurity mandates, as put forth by the government, could be changing from time to time. Regulatory laws for AI, IoT, and blockchain may have such legal uncertainties. These are caused due to the teething trouble for such laws in India. Ventures might have to regularly monitor specific regulations relating to their respective industries and must stay updated. Changes in law, such as Information Technology Act, Consumer Protection Act, Digital Personal Data Protection Act, must be regularly kept in track by business. A venture needs to be consulted with by a legal professional to determine whether software ought to be licensed as a product or as a service, therefore avoiding misclassifications. Frameworks such as ISO 27001 or frameworks as per the NCRF, that is National Cybersecurity Framework, must be implemented to comply with regulations, which we need to do so by consulting the appropriate professionals who can address new compliance needs from time to time. Now, the risks that are usually associated here are non-compliance with industry standards. Certain sectors have additional regulations. For that, the solution is we need to regularly monitor sector-specific and emerging tech regulations, thereby being updated. Second is licensing issues. Misclassification of a software can result in tax or licensing penalties. Therefore, it becomes essential that you consult legal professionals to determine if a software should be licensed as a product or service, avoiding misclassification. You should also sometimes consult the CA with regard to tax classifications as well. Third risk is cybersecurity and cybersecurity requirements. Government often mandates cybersecurity practices and incident reporting. For that, we need to implement frameworks like ISO 27001 or NCRF or CERTIN to comply with cybersecurity regulations. Then the last that I can think of is emerging tech compliances. Artificial intelligence, IoT, and blockchain may have legal uncertainties. For that, I think the only solution is we need work with tech-specific legal experts to address the new compliance needs. Someone who understands the technology as well as the law and who's also updated on the law, which is now constantly evolving because AI is a completely new field. There is actually no law on AI because people don't know what is the extent of AI. Without knowing the extent to which a particular tech venture can go to, it is very difficult to frame a law, to bind that particular industry. Now we'll go on to the last risk that I'm going to speak in detail. That is the employment and workforce risk. Now, employment and workforce risk are significant for tech ventures in India, given the rapidly evolving legal landscape and dynamic labor market. Now, this is a risk that is mostly overlooked by various ventures. This is one of the most vital issues that might lead to huge disputes, eventually resulting in loss of business. Now, non-compliance with Indian labor laws might lead to fines, penalties, or legal disputes. The government also introduces new labor codes, making compliance more and more complex. Now, the problem now is that the government has introduced four labor codes, but we still don't know whether they are, in existence. People, we are all still using the old acts. There's a huge uncertainty with regard to the new labor laws. Privacy of users are paramount as far as private tech ventures are concerned. So leak of such data will lead to data and theft of intellectual property. These leaks could be due to technical malfunction or internal sabotage. So leak of sensitive data could be due to the usage of such data by ex-employees. Weak NDAs can lead to such usage of theft and misuse of information. Now, any venture must have an airtight NDA with the employees in order to protect sensitive data. I've always said this, problem with this is we don't follow through with an NDA. Most of the members that I have interacted with, they don't want the hassle of a legal cases, but that is okay because it depends on how badly the data is being misused. If the data is being misused and we have an NDA in place, then we need to sue for the breach of contract, which is the NDA. Now, we also need to have workplace ethics and guidelines to be monitored closely. All entities must establish internal complaint committee as mandated by the Prevention of Sexual Harassment Act. That is compulsory now when there is a particular amount of employees working and if there is a female employee in employment. Now, mandatory sensitization programs on workplace ethics and anti-discrimination must be conducted by all companies to ensure workplace ethics and conduct. Also, offering employees with ESOP or equity agreement and mismanaging it can lead to conflicts, and agreements in relation to stock options must be binding on both the parties, and clauses of the agreement must be set out properly to enforce the terms and conditions. This could be achieved by working with legal professionals to structure the employment stock options and thereby prevent disputes. Now, what are the various risks that you can be associated with in this sector is misclassification of employees as contractors can lead to regulatory action. Clear employment contracts needs to be drafted defining the employment status and roles so that there is no confusion as to who they are. Are they an employer or they're a contractor? Because if they're an employee, different laws apply. If they're a contractor, a different law applies. Leaks of sensitive data or technology due to weak NDAs can lead to data and IP theft. Now, strong NDAs or non-compete clauses are required in confidentiality agreements for all employees, contractors, and partners. As I don't know if you're aware of it, I had drafted one employment agreement as a draft for all the members of ISODA. In that agreement, I have included non-compete, I have included confidentiality clause, NDA, everything. We need to have a very strong and binding employment contract. Only then we can, seek to enforce them and have some control over the employees. Then third possible risk is unfair treatment, harassment, or discrimination claims can harm the company's reputation. For that, we need to properly train the employees in the workplace standards, maintain policies for fair treatment by establishing anti-discrimination and harassment policies. And POSH is always required to be there for in any company when women are working. We need to be able to also put in proper sensitization programs to establish clear roles. The next possible risk is mismanagement of stock options or equity agreements that can always be properly uh, vetted with the help of a legal advisor to structure it and prevent any disputes in the future. The governing laws with regard to this is Employment Provident Fund Act, Industrial Disputes Act, Minimum Wages Act. These are the principal acts which applies to labor and contract workforce. Because the new labor codes have not yet come into effect. That is the problem. There's still some confusion with regard to that, some uncertainty. So till the uncertainty is clarified, you will still be relying on the old laws. Another risk that we'll be venturing on today is technology licensing risk. Technology licensing is a contractual agreement in which the licensor's intellectual property is transferred to the licensee for a specific period of time. The consideration for licensing is in the form of royalty, and such clause is to be finalized before executing the licensing agreement between the parties involved. Now, technology licensing is an essential tool for companies that are smaller in size or do not have R&D resources. This licensing is vital method for a small company to stay on its feet in a long run. Technology licensing can be a walk on a knife if not executed properly. Under licensing or over licensing could lead to financial loss or even data loss. A company can start using technology licensed indefinitely without any restrictions if not executed properly. This can be curbed by regular license audits to ensure compliance and avoid unnecessary disputes and expenses. The risk that is involved here is license management under or over licensing can lead to financial loss or legal exposure. Solution: conduct regular license and audits to ensure compliances and avoid unnecessary disputes and expenses. Vendor lock-in or long-term exclusive contracts can limit flexibility and lead to increased cost. We should always negotiate for non-exclusive or shorter-term licenses wherever possible to create flexible licensing arrangements. Another possible risk is misuse of open source code in proprietary software can lead to legal action. Now, for that, we need to adhere to open source licensing requirements and include an open source policy in development so that it is not misused. Gentlemen, I think that is it. There's some risks that I've not gone into it, but this is predominantly the most important risk that any company should be aware of. If you have any doubts, please let me know. You can go to the question and answer session right now. जी जी am I audible? Hello.
Yes, yes.
No, I was just saying I'm done. So if there's any question and answers, just please feel free to ask me so that we can bring this webinar to an end.
With respect to, in case an agreement between two companies where it is going to be internationally signed, is there anything which can you share some lights on that?
Yeah, so I've come across some agreements. I've always stated that, when jurisdiction clause, there's a particular clause in a contract which says jurisdiction. So the contract, if there is a breach, which jurisdiction of court will apply, whether that country or this country. I always advise to my members, let's put our country because it's easy for us to have a dispute here rather than in other foreign courts where it's highly, expensive, and also it's difficult for us to go to a foreign country. The problem is, most of these foreign companies insist on having a, what do you say, jurisdiction which is abroad. Unless we
Yeah.
put our foot down and saying, no, we need it here in India, it is a negotiating tool between the two companies. It could be either company, it could be either country. So it depends on how important it is for you to have the contract. So I would suggest keep the jurisdiction clause in India, or if worse come worse, you can have arbitration in Singapore, which is not far, or in Dubai
Oh,
under the international
oh,
arbitration rules. So then what happens is you, for example, if you're the company with whom you are entering into an agreement is in the US or Australia, and if they get priority over the jurisdiction, then you'll have to go all the way to US or all the way to the Australia for filing a case. In spite to get over that, we can say we'll agree to arbitration in Singapore or Dubai under the international arbitration rules. Then I think it'll be easy for us. We can at least go to Dubai or Singapore rather than going all the way to
oh,
the US. That's one way
yeah.
of doing
And another point with respect to NDA, whenever we sign an NDA with a customer,
it.
there are a lot of RFPs and other stuff where we may have to share the POs and other stuff of the customer for the RFP.
Yeah.
Is there anything specific we have to look at the NDA where whether we can share these POs for these RFPs?
I'm sorry, I didn't get the last part. What you were saying? Is there
No,
anything?
so anything specific we have to have this included in the NDA to share these POs for these
No, see, so
RFP
NDA,
process.
non-disclosure agreements will define what information is. Their definition of an
Can
information
be shared.
quite expansive. So you can take away some points or you can include whatever you think is information. It can be anything, even a phone call to that person can be
Okay.
information. Now that has to be defined in the definitions clause on the contract. Every contract will usually have a definition clause saying what are the terms that's being used, what are the definitions. In an NDA or a confidential agreement is usually information. What is considered to be confidential information that needs to be defined clearly. Once you include that in that clause, then you'll be safe. But you need to identify what are the areas that you want to include in that definition. There's already one NDA that I've taught for the ISODA, which is on the website, which will contain a lot of various meanings of information. It could mean anything. If there's more than that, you can add it and also and use it, or you can detect some and use if it's not relevant for you. It has to be properly defined.
Okay, that's great. Yeah, that's it. Thanks.
No problem, Venkatesh. Anyone else got any doubts? Well, I guess that's it then. Thank you all for this opportunity to, address you on
I
this.
have a unique question. I don't know whether
Please.
he'll appreciate or not, but then I want to ask this.
No, please.
Sir, please understand, if we have interviewed a candidate, given the job offer, he has accepted, we waited for the notice period and he's supposed to join, say, after 1 month or 2 months, the notice period. And the last day, they don't join because they get some other offer, negotiate, correct?
Of course.
And
Yes.
this happens to everyone. I'm sure everybody in this
It happens to all of
will
you.
appreciate, right?
Yes.
So it's like they look for the best offer, and they have every right to look for the best offer and join because it's their career. Is this correct, sir?
Yes.
Okay. And as a company, we can't do anything because it's a candidate's choice. Now, my question is very simple. The same way, if I choose a candidate and give an offer and he has accepted, maybe I get, and his date of joining is, say, 15th of December. But I get on 10th September a better candidate, then why can't I revoke my the offer letter and say, well, we have got a better candidate, so I'm not
There
taking
is a
we are
reason
going
for
second
that.
one.
As
We
a
will be
company,
taken for granted because what I'm saying, as a company, a lot of bad mouthing will happen about us.
It's
But
not
why
that.
this?
There's a legal basis for that.
Is
As
what
a
I want to understand.
company,
Yes.
you're an
Yes.
artificial person. An
Pardon,
artificial
sir?
person does not have a fundamental right.
Pardon, sir?
As a company, you're an artificial person. You
Okay.
don't have fundamental right. So your employee has a fundamental right of employment, guaranteed in Article 19 of the Constitution of the country, freedom of life.
Correct.
As a company, you don't have freedom of life because you don't have life. You don't exist in reality. You exist only on paper. That is the unfortunate thing. But there are certain scenarios where, if, for example, you employed somebody, you have trained them for over a period of 6 months or 1 year.
I understand.
Give them very specific training, which is very exclusive to you and maybe few other companies, not that many companies. Then there is a clause in the contract saying that you will have to work with me for a minimum of 3 years.
That's okay. That's
If he terminates that contract, you have every right to file a case against that person. So the problem is, even otherwise also, you'll have to file a case. Most of you don't file a case because you don't want to be hassled with the legal process. See, the thing is, unless we file a case and put the fear of litigation in litigants, in employees, they will not be bound by honoring contracts. They'll simply say, I got a better offer and I'll leave. See, at least they have to serve notice period. If it's 1 month, 2 month, they have to serve the notice period and then they have to go, or give up the salary in lieu of those 2 months. No one follows that. The only way to enforce that is to file a breach of contract claim against them in a court. But that again, you'll have your own issues with that because it's a time consuming.
I understand. So this is a separate topic. Okay. If we have trained them and we have a contract for that, we can file a legal contract. That is a separate thing. But I was coming from the other point that every law seems to support the candidate and his well-being, not the company's well-being, is where I'm coming from. That if
No,
a
that is where
candidate has the right to choose, then company should also have the right to revoke and choose the best.
Yes, you can. You can. It depends on the terms of the contract. If you see, if that's what I'm saying, a contract is not one-sided. A one-sided contract is not valid. Invalid, by the way, under the Contracts Act. It cannot completely favor you, or it cannot completely favor the work employee. So if you want to employ somebody else, basically what happens when you're employing a fresher, you'll give him a probation period, 3 months or 6 months. In that probation period, you can fire him indefinitely without any notice period because he's only on probation. Post probation, you need to give 1 month's notice or 2 months notice, whatever is your practice. That applies to you also. And that applies to him also. Like if he wants to leave the company, he has to give notice and go. If you want to terminate him, you have to give him notice. Nothing stops you from terminating, or in some contracts you can have a clause. You can indefinitely terminate that employee without giving any notice if he does something high misconduct like theft, cheating, or sexual crime. something of that nature, without notice also you can terminate. But then again, it's all limited. It's not generally you can't terminate anybody without giving
So
notice
I'm
period.
again
Notice
coming to a
period
point.
is
You are
essential.
talking of after employment. We have the probation period and we can always look if the guy is not performing. That's okay. I want to understand before employment, if I, as a candidate, accept an offer from a company, suppose you are running a company and I accept and give writing, yes, I have accepted the thing. Is there any legal way to hold him accountable that you have accepted, then why you are not joining? He takes the offer and negotiate with 3-4 companies, and then he chooses the best one. I'm saying even before that joining, can company have also a right to choose the best candidate and revoke some upon later he is given to a particular candidate because I found a better candidate? Why law is not hears both sides? Why it is not favoring both sides?
So thing is, the problem is, let me understand your question first. You're asking before the commencement of agreement,
Yes, before
employment.
the candidate joining, what is happening today? Candidates are taking one offer, negotiated with 5 companies, and then trying to take the best offer and join some company. But he is confirming to a company. For example, he is confirming to us. Yes, he is joining by 15th December. So we wait for 1 month of his notice period or 2 months of notice period. On the last day or 1 or 2 days before, he says, well, I have got a better offer. I'm not joining. But he has already confirmed that I'm going to join, and we have waited for 2 months for him to join. And this is a pain of all the partners.
If he has confirmed, as he signed the contract.
Sign the contract, they don't normally, it is all email, no? We do a
No, that
version.
is a problem.
That is,
that
give
is
the
the thing.
confirmation
Because
on email. Yes, I'm joining and all. Yes.
No, that will not suffice. What you should do is, if that person says, I'm joining your company, you immediately send a contract and get it signed.
Okay.
Once you have a signed contract, then that person can't leave you and go. Unless you have a signed contract saying that I am bound to you, he cannot
But
then
here
leave
he
you
will
and
not
go.
be able to sign a contract when he's working for another organization, right?
Yes, he can't. He should not. That will be a clause in your agreement.
No, but if you're
Yeah, so no. His question was he's working in an organization where another organization has given an offer. He is there in a notice period. In between, he gets another offer, better offer. He goes.
He can go,
So
but
in that case,
he has to serve notice period.
No. But yeah, in the other organization, whereas the organization which given the offer to him accepted and is supposed to join, he is not. He never joins. He gets another offer. He leaves. Ms. Mehta's question was whether we can cancel an offer which has been given to a candidate, whereas in between we get a better candidate. Is what the question which Mehta Sahab was asking.
See, that's what I'm saying, sir. If you
Pradeep, you have understood the question actually because it's a little bit tricky. So
no, problem is there's some network disconnection. I'm only hearing half of what you're saying. I think there's some miscommunication. But let me try to understand what you're saying. So you're saying that there's one person.
I will repeat again, sir. I will
who's
repeat
serving
again.
notice period in one company.
Sir, I interviewed a candidate.
Okay. Now, is that candidate
Gave
working
him the offer. He accepted the offer. As of now, we are doing through email or through portal. Okay. He accepted the offer. And based on that offer, he resigns from his present company.
Okay.
In the present company, he has a notice period of 2 months.
Okay.
So he starts serving the notice period of 2 months. We as an organization keep on waiting. Okay, his notice period is 2 months. So he will join by say 15th of January 2025. Correct? He has confirmed. We are waiting for him. Now, he is in notice period in the present company. But what he does, or many candidates are doing that, based on our offer, he will also give interviews to 10 other companies.
Yeah, got it.
Will negotiate and all, and he will have 3-4 orders in hand. So fine, we understand. He is trying to do his best. We understand that. But he has given a commitment to join to us Joining date is 15th January. It is confirmed over the email. And we wait for 2 months. However, he gets something better, and 1 or 2 days before joining, he will say, when we follow up for the
He
joining, he will
leaves
say,
you in offer.
he says, I have got a better offer, I'm not joining. Okay?
Okay.
Okay, this is one scenario. So
So
now
you're
here
saying
the
why
law will
not
support.
apply for me also?
Pardon, sir?
If somebody is joining my company, is accepted to join my company on X date, and before that date, you find somebody who you want now, not this person who's already agreed to join.
Now
Is that what
the
you're
law is supporting the previous case that, okay, candidate has the whole moral right and he has legal right to choose the best offer. I understand. The same way, so that means he has confirmed to us is not valid, or there is no legal protection for that. Then as a company also, when we have sent an offer letter by email, and he would have resigned based on that email, but I should also have a right that 2 days or 3 days before I can say, boss, we have selected you, we have given the offer, but then we have got a better candidate. There is no need, your employment is terminated. We are selecting another good candidate. Now here,
I
we
got it.
go for a legal case that based on our offer, he has resigned and blah, blah, law will support him only. So I am telling,
Yes.
why not, this is fair on both sides. If he can choose the best company, I can also choose the best candidate. If my confirmation, if the
No,
confirmation to our company is not valid, then our confirmation to candidate also should not be valid, and we should also have the right to choose that. Am I clear? I'm sure the
Sir,
other
I understand. I
appreciate.
understand. No, no, I completely understand right now. But now you're talking hypotheticals, which is not covered by law. You're a
Not
company.
hypothetical. This is
So the
happening day in,
problem,
day out for everyone.
no, hypothetical with regard to the law. Situation as such is happening in ground.
Yes, yes, yes.
What I'm trying to say is, like I said, as a company, you're not born with a constitution. You don't have the right to Article 19. As an employee, he's got the right to Article 19. That is the problem. Right of life includes right of work also. He's free to work where he wants.
Correct.
See, what you're saying is it's a very, very niche area, which is very difficult to legalize. You're saying, you look at it this way. Based on your offer, I have resigned from my company. Now I'm going to come and work for you. But you find somebody else. So you want to rescind my offer and employ him. That is unfair.
I know it is unfair, but I am saying it is unfair on the other side also. When the candidate has given a confirmation to join us, based on that, we waited for 2 months, then our effort is also lost. And if he has a right to choose the best offer, I also should have a right to choose the best candidate. I'm saying law should be equal both sides. The way you are telling notice period should be same on both sides. This also should be same on both sides, is where my contention is.
After signing of the contract. I really don't know how to answer this, to be very frank with you, because
I'm not a
this is
lawyer,
very
but I want to seriously fight for it. Why this right should not be given? Because
Pradeep.
everywhere I feel employer is always on the wrong foot. Law supports the candidate.
No, that's because you're the David, you're the Goliath, sir. The employee is the worker, David. You're
No.
always the Goliath. The law supports the weak, not the
Pradeep,
strong.
So it is the victim when you are telling, that means we are assuming all the employees are bad. All
No,
employees
I'm
are
not saying
sorry. So
that.
it is
See,
not bad.
at the end of the day, not everybody is bad, not everybody is good. There are
Correct.
some really good companies, some really bad employees. Really
Correct.
bad companies, good employees. That's all there. Problem is, you're talking about a very specific scenario where the scales are in the employee's favor, not really in your
Pradeep.
favor. Because,
Hello.
yes, sir, Zakir, sir, tell me, sir.
Pradeep, can you put this Mehtaji's question to the President of India? Well, I have another question to
You
ask.
should draft it.
Okay. So after putting this to ISODA can fight, and then we can become more famous, And this will
That
help
is up to you if you
all
want
the
to become
employers.
famous or not. I'll help you
Hey,
So
with
I have
that.
one question. Pradeep. As per the agreement that you have given for
Hey,
the
Zakir bhai, you want my question to be answered or not? Let my questions be answered first.
सर वो अभी वो जलेबी एकदम बड़ा हो गया सर, वो किसी का मुंह में ही नहीं जाने वाला है, तब से गोल
सर
गोल गोल घूम रहा
वो
है।
आपका क्वेश्चन का कोई आंसर नहीं दे
हाँ
सकता
आंसर
हूँ.
नहीं है, ठीक है?
आंसर नहीं है
कोई
तो
डिफिकल्टी है. आई एम ऑनेस्टली सेइंग उसका कोई जवाब नहीं है.
You tell me, I will like to fight the case for us. You support us, we like to fight. Why it should be unjustified to an employer like this? Because everybody is suffering because of this. And this is encouraging more and more such instances. So when the things are happening wrong, then the law should come in place. There has to, if there's no law, maybe.
And what should happen is you should you should take the risk of facing a case. Which employee is going to file a case against you?
You will fight the case, then tell me.
No. I'm saying you're saying that you ask somebody to come and join you on Jan 15th. That person has resigned. Now you're saying somebody else is now you found. You want to bring him into the picture. You bring him into the picture, you rescind that offer. What is he going to do? He's going to file a case against you. You fight the case. He might win, he might not win. As a company, I can always say that, yeah, I wanted him to come, but then I have discovered that I got some report from the other company saying he's not good at his work, or be honest about it, saying I got a better person. I have therefore engaged him. I'll pay him 1 month or 2 months compensation for that period that he is, in terms employment with me. You can do that. Nothing stops you. So you will have to face the court. If he goes to court, but who goes to court nowadays as against the employer? Tell me. How many cases does employees file against you?
But if we go for a case, if the candidate goes, assuming he goes for it, then we are bound to lose, because there the law will
No,
support.
not really.
Because he resigned based on our offer, and then we are not giving the offer,
3216.
then the law will support.
Yeah, that's the
But
thing. If you go to court also, you can tell the court that your requirement at the moment has changed. Your requirement is for somebody with a better experience, with a better capability. And because he is resigned, I'll pay him 2 months salary or 3 months salary as compensation. Not more than that.
Okay.
That's one way of doing it.
This is one way, I understand, but we are looking into both ways side ki that I want to have that case compensated for employer and employer, that there is a law itself should be changed in this.
The thing
that
is, at the
both
end of
have
the
a
day,
right.
once the contract is signed, that's when everything starts. You given an offer, he is accepted, that's all still prior to employment. You have not signed the contract. So even this person who's resigned, you have not signed the contract. So once the contract is signed, only then you're bound by all these things. You are still free to terminate that person. So don't give him an acceptance offer. Leave it open-ended.
Anyway, I think it will need a larger
Pradeep,
discussion. I think
Pradeep,
Zakir
I
bhai,
have one question.
Yes, sir.
Pradeep,
Thank you so
we have
much.
a contract with a employee and he leaves,
Ah,
and we take a on a bond paper that the data will not be misused, or and now this employee joins a company, and after working for 4 5 months he leaves that A company and joins a B company, and then misuses the data. Then what is the law? I mean, but that.
So first of all, the two steps to it. First
Hmm.
step is when you're having an employment contract, that
Yeah.
contract should clearly state for how long he is not supposed to use your information. 1 year, 2 year, 3 year, 4 year.
Okay.
Once you define the time period, it does not matter how many companies he joins afterwards.
Okay.
Cannot use your information.
Okay.
If he uses the information, then you can still sue him for misuse of information, breach of
Okay.
contract.
Okay.
Some clauses exist even after termination. That is this confidentiality clause with regard to information. That it exists even after the contract has been terminated.
Okay.
So basically, for example, in one scenario, some contracts will have a non-compete clause. So, for example, if somebody is working for you, if he leaves your employment, he can't go work for your rival company for a period of 2 years.
Okay.
That kind of a clause is valid, is
Okay.
recognized.
Okay. So this can be written in so generally when a person leaves my company, we signed on a stamp paper that he's leaving and is.
No,
So
no,
in
no.
there
This
we
should
can
be
write.
done. This should be done when he joins the company. You should have an
Okay.
employment agreement with him, saying that in case of a termination, he cannot use this information for a period of 2 years. And then when he's leaving the employment, you have one letter saying that I will abide by the terms of my contract, wherein I have stated that I will not use this information for a period of 2 years, 3 years, or whatever it is. It's got to
And
be
another,
at the beginning and also at the end.
okay. And one more thing.
That is stronger for you.
Okay, one more thing is that generally these contracts are sent by email, and there are no signed copies at both the ends. So will this work?
Contract can also be digitally signed, no? That
Okay.
person can always sign the contract digitally and send it to you. It's recognized by the IT Act now.
Okay, so but the signature is necessary.
Yes. Digital signature is necessary. So basically, what happens is on email, if you send him a contract, he's seen the contract. It's just an offer sent by you. Unless he signs that contract and sends it back to you, your offer has not been accepted by him.
But let's say he starts to working and he's getting a salary also now.
That is a legal loophole that you need to close.
So even if he's getting a salary for 1 year and if he leaves, still he's not bounded by the contract, correct? That's what you say.
Technically, not, but you can argue in the court that he's a part of the company. See, problem is you're talking about situations. It's something as simple as getting a sign on a document. When somebody is joining your company, you please get the employment agreement signed. That is simple. Don't go think about any other situation. Get that signed. Digital signature also is valid. Because we need to first safeguard our priority. Otherwise, then we'll be left in a legal loophole, which they can make use of, and we will suffer. That is our problem. So tomorrow also, if I go to the court will ask me, why did you not sign the contract? Or why did you not ask me to sign the contract? So then what happens is he's working on a contractual basis, month by month. Every month you're paying him salary. The court can construe his employment as consultancy employment, not a contractual agreement.
Okay, got that. Thanks.
That's right. Okay, sir. Anyone else? Any doubts? Anything? Or should we wrap up this webinar?
So we can close, I think.
Okay. All right. Thank you, gentlemen. Thank you for patiently listening to me. It was a pleasure being here. Thank you.
Thank you, Pradeep.
Thank you.
Thank you.